In this video, I'll explain how to fire a business partner in Florida without losing the company, the delicate legal choreography of removing a co-founder. And by the end of this video, you will learn the exact steps you need to take before, during, and after separating from a business partner so you protect yourself, your assets, and the future of your company. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I've walked dozens of business owners through this exact situation, and I can tell you, most people get it wrong because they let emotion drive the process instead of strategy. Here's what I mean. Nobody starts a business thinking they'll one day need to rush out and push out a partner. You launched this thing together. You shared the risk. You probably shared late nights, personal savings, and a whole lot of stress. So when the relationship breaks down, it feels personal because it is personal. But here's where people destroy their own companies. They act on frustration. They fire off angry text messages. They change the passwords. They lock their partner out of the bank account on a Friday afternoon. And just like that, they've handed their partner a lawsuit on a silver platter. I've seen it happen more times than I can count. A founder comes to me after they've already made the first move, and now they're playing defense instead of offense. That's the worst position to be in. So let me walk you through how to do this the right way, step by step, because the order of operation matters more than you think. And before you say a single word to your partner, you need to pull out every agreement you've ever signed together. I'm talking about the operating agreement, the partnership agreement, the bylaws, the shareholder agreement, whatever governs your business structure. These documents are your roadmap. They tell you what you can do, what you can't do, and what process you have to follow. And most operating agreements contain provisions for removing a member. Some require a vote. Some require cause. Some allow a buyout under specific conditions. If your agreement has a for cause removal clause, you need to understand exactly what qualifies as cause. It might be a breach of fiduciary duty, and it might be fraud. It might be failure to perform agreed upon responsibilities. Whatever it says, that language is going to control your entire strategy. Now, here's the hard truth. If you never drafted a formal agreement, and many small business owners don't, you're going to be governed by Florida's default partnership or LLC statutes. In Florida, that means the Florida Revised Uniform Limited Liability Company Act, and those default rules may not give you the leverage that you think you have. And this is why the very first thing I tell any client is this: read the documents before you make a move. And once you know what the document says, the next phase is documentation. And I mean serious, methodical documentation. If your partner has been neglecting their duties, you need records. If they've been making unauthorized financial decisions, you need statements and receipts. And if they've been violating the terms of your agreement, you need a paper trail that proves it. Think of this like building a legal case, because that's exactly what you're doing. Even if you've never end up in court, the strength of your documentation is what gives you leverage at the negotiation table. Save every email, screenshot, every text, pull financial records going back at least 2 years, and keep notes with dates and specific incidents, and store all of it somewhere your partner cannot access. I know this sounds cold, but it might even feel like betrayal. But let me be clear about something. If your partner has been damaging the business, protecting the company isn't betrayal, it's your fiduciary duty. And here's a critical point most people miss. You should be doing all of this before your partner has any idea that a separation is coming. The moment they sense something is off, they start covering their tracks. They start moving money, and they start talking to their own attorney. You lose your advantage completely. Now, if you're finding this helpful, do me a quick favor and hit that like button and subscribe to this channel. It helps more business owners find this information when they need it most. All right, let's keep going. Now comes the part everyone dreads: the actual conversation. All right, here's my advice. Don't approach this as a firing. Approach it as a buyout discussion. The framing matters enormously. When you tell someone that they're being removed, They get into fight mode. When you present a buyout offer, they start thinking about the numbers. You want them thinking about numbers. And before you sit down, work with your attorney and your accountant to determine a fair valuation of the business. Know what your partner's share is worth. Have a number ready. Have a payment structure ready. And be prepared to negotiate. But also know your walk-away point. The goal of the conversation is to reach a voluntary separation agreement. That means your partner agrees to leave in exchange for fair compensation. This is almost always cheaper, faster, and less damaging than a forced removal or litigation. If your partner agrees in principle, get the terms in writing immediately. Not next week, not after they want to think about it for a month. The longer a handshake deal sits without documentation, the more likely it's going to fall apart. Your separation agreement should cover the buyout price and payment terms, non-compete clause, a non-solicitation clause, intellectual property assignments, a mutual release of claims, and a transition timeline. Every one of those elements protects your company going forward. But what happens when your partner refuses to leave? What if they dig in? This is where things get complicated. And this is where having an experienced attorney isn't optional, it's essential. If your operating agreement allows for a vote to remove a member, you may need to call a formal meeting and follow the exact procedures laid out in that agreement. Miss a single procedural step, and the removal can be challenged in court. Now, if your partner has genuinely engaged in misconduct, embezzlement, self-dealing, breach of fiduciary duty, you may have grounds for a judicial dissolution on a court-ordered removal. In Florida, courts can intervene when a member's conduct makes it impractical to carry on the business. There's also the nuclear option, dissolving the company entirely and reforming it without the problematic partner. This is drastic, and it has tax consequences, and it can disrupt client relationships and your contracts. But sometimes it's the cleanest path forward, especially when the operating agreement doesn't provide a clear removal mechanism. I want to be honest with you. Contested partner removals are among the most expensive and emotionally draining legal battles a business owner can face. That's why I push so hard the negotiated buyout approach. Prevention and preparation save you from warfare. And one more thing people forget. During any removal process, you need to protect the business operations. And that means reviewing who has signatory authority on bank accounts, who controls the company's digital assets, and who has access to client lists and proprietary information. Lock down what you can legally lock down, but do it properly. Unilateral lockouts without any legal authority can backfire spectacularly. And once the separation is finalized, the work isn't over. You need to update your operating agreements. You need to file any required amendments with the state, and you need to notify your bank, your vendors, and potentially your clients. Now, if your former partner had personal guarantees on business loans or leases, those need to be addressed. Lenders don't automatically release a guarantor just because they left the company. And take this moment to do what you should have done from day one. Build an airtight operating agreement for the company going forward. Include clear removal provisions, buyout formulas, dispute resolution mechanisms, and defined roles and responsibilities. The best time to plan for a breakup is before you need one. Now, if you're dealing with a difficult partner situation right now, don't wait until it boils over. The earlier you get proper legal guidance, the more options you have, and the less it costs. Now, if this video gave you clarity on what to do next, hit that like button and subscribe to this channel so you don't miss the next one. Every week, I break down the legal strategies that protect business owners just like you. I'm Santiago Cueto, your Florida business attorney, and be sure to watch more of my videos right here.